I call this meeting of the Conference Committee on House File 2130 to order. There is a quorum present. It is May 15th, 2025. So welcome everyone today. Today we're going to be acting on House File 2130. This bill comes out of really a horrific tragedy that happened in St. Louis Park in the district of Senator Latz, that Senator Latz and I represent, back in September of last year, when a driver who had 5 prior DWIs plowed through an area of Park Tavern, an outdoor patio, killing 2 people and injuring 12 others. This has been a journey here. I reached out about trying to understand our DWI policies just a few days after that. Chair Moeller provided me some really great guidance there and connection to folks, and Senator Latz as well has been with me every step of the way on this. So I'm excited that to bring this forward, close this up, and then get it passed in both houses. So with that, Senator Latz, any comments you'd like to make?
Well, this has been quite a journey. This has been quite a journey here, but it's born of a tragedy and hopefully will help prevent future similar tragedies.
Okay, so to begin, I'm going to have staff walk through the differences in the House and Senate language. If I could ask Mr. Johnson to do that.
Mr. Chair, members, the bills in front of you are nearly identical. There are only a few small differences between the provisions that passed the House and the Senate. The first difference you can find is on page R15. That's R15 of the side-by-side. On that page, there starts a Senate-only provision, and the change is actually on the next page. This has to do with the standards that the ignition interlock providers have to meet to be certified and allowed to operate within the state. There's a change that references that they have to be compliant with the current law when someone is voluntarily leaving the program. Right now, it applies only to voluntary termination, and this reference adds when somebody suspends, essentially steps away voluntarily, is not terminated, but chooses to walk away from the program. It's essentially a conforming change with another Senate change that we're going to get to next. If you go to page R19, I'm going to talk about the differences on the Senate side before the House provision. There are 2 sections. First is on page R19, and the next is on the top of R20. These are 2 Senate provisions that deal with what happens when a person either involuntarily or voluntarily leaves the ignition interlock program. Both provisions essentially address the credit that a person would receive if the person restarts. Under Section 10, the suspension of participation is a voluntary leaving of the program. And under this standard, a person could voluntarily leave the program if they no longer had an operating vehicle or if they transferred their vehicle. And when they restarted the program, they would get credit for restarting. The second provision, which is the subdivision 11, Senate section 22, is when they are terminated from the program. So this is not necessarily a voluntary decision. This is when they are removed from the program. In that situation, this also would allow them to restart the program. And if they restarted the program, they would, under this, get credit for the time they had previously been in the program. The other difference between the 2 bills is on page R19 on the House side. And this is an appropriation. It's an appropriation not from the general fund. It's from the Driver and Vehicle Services Operating Account, which is a special revenue fund. The total amounts are $382,000 each year, beginning in fiscal year 2026. And those cover the costs related to this expansion of the interlock requirement. This language has passed the Senate. It's in the Senate's public safety bill. So while it's not here in the side-by-side, it is a Senate position in the public safety bill. Mr. Chair, that is the end of the walkthrough of the differences.
Thank you, Mr. Johnson. Any discussion or question from members? Senator Limmer.
Thank you, Mr. Chairman. The question that was just discussed, the $382,000 in each year, 26 and 27, having been in the larger Senate bill, is the dollar amount the same?
I believe it is Mr. Johnson. Do you want to comment on that, or Mr.
Yeah.
Backus?
Mr. Chair and Senator Noem, I can answer that. Those numbers do match up.
They do. Thank you.
Any other questions? Okay, so it's the committee's intention to adopt the House language in House File 2130, the fourth engrossment, with the three amendments that have been agreed to. We'll be going through them shortly. There is a provision the House is accepting in the Senate language. We'll go through that as well. The amendments are posted online and included in your member packets. So I think we'll start with the A7 amendment. Mr. Johnson, can you please explain the A7?
Mr. Chair, members, the A7 amendment should be in your packet. This is an issue that the Department of Public Safety flagged for everyone after the bills had passed both bodies. In the bill, there is a provision that increases the penalty for someone who is on the ignition interlock program and then drives a vehicle that's not equipped with an ignition interlock device. It increases that penalty to a gross misdemeanor. DPS pointed out that there is an existing penalty for that in current law that is a misdemeanor. This harmonizes the two. It increases the existing penalty from a misdemeanor to a gross misdemeanor, and it replaces the new penalty that's in the bill with a cross-reference to that existing bill. You can see that new language on the second page. The page 2, line 10 is the increase to a gross misdemeanor, and then the change on lines 16 and 17 of the second page include that cross-reference. Mr. Chair, that's the explanation of this amendment.
Thank you, Mr. Johnson. Representative Whitty, would you like to offer the A7 amendment to House File 2130, fourth engrossment?
I will.
Representative Whitty moves the amendment, moves the A7 amendment to the House language, House File 2130, fourth engrossment. Is there any discussion to the motion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? The motion prevails, and the amendment is adopted. Next, we will move to the A8 amendment. Mr. Johnson, can you please explain the A8?
Mr. Chair, the A8 should also be in your packet. There are several changes here. I think the easiest way to explain this is to say that there are three situations where a person who is on the ignition interlock program may no longer be able to drive for a short period of time. The first situation is where the person who is on the interlock program commits a driving offense that does not in any way involve the use of alcohol. So we're talking things like excessive speeding, a different way to lose your driving privileges. In that situation, under the A8, the person would be allowed to remain in the ignition interlock program to continue to use that device to monitor sobriety if the person chose to do so, but would not be permitted to drive in the same way a normal person with a normal driver's license would lose the ability to drive for the reason of the excessive speeding or a different sort of violation. That person could also voluntarily withdraw from the program during that period of time and not drive at all and not have a vehicle at all. If the person chose that route and voluntarily withdrew from the program and then re-entered the program after the suspension time was over, that person would get credit for the time already in, essentially picking up from where they left off during that suspension period. That's option number one. The second option involves a situation where a person has an alcohol offense that does not involve driving. So if a person has another conviction for something that involves the use of alcohol, that is a demonstration that that person is not maintaining sobriety, which is a requirement of the ignition interlock program. In that case, the person can continue to drive and must continue to use the ignition interlock device, but they restart their revocation period. Their ignition interlock requirement starts over. They get credit in this case for half of the amount of time that they have already spent on the program. So for example, if they have a violation after a year, they would have a 6-month credit based on restarting their time. So if they had a 2-year period of time and they completed 1 year, they would have to go back and complete an additional 18 months. The third scenario is when the person has an alcohol-related driving offense, a new DWI or something similar. In that situation, they are effectively terminated from their existing participation in the program. If that person continues to drive, chooses to continue to drive, they must be back on the ignition interlock program. But the time period they have to do is going to be the longer of either the new revocation period. If the new offense has a longer revocation period, they have to complete that revocation period. or if the original revocation period was longer, they have to restart that period. That situation would be most likely to come up if, for example, a first offense was a criminal vehicular operation offense, which has a longer suspension period, and the second offense was a DWI, which would have a shorter period. The person does not get the benefit, if you will, of a shorter revocation period for that second DWI. Instead, they have to start over on the longer period, which would have been the revocation period for the criminal vehicular operation offense. That is what the A8 accomplishes, Mr. Chair.
Thank you, Mr. Johnson. Senator Latz, would you like to offer the A8?
Mr. Chairman, I move adoption of the A8 amendment.
Senator Latz moves the A8 amendment to House language, House File 2130, fourth engrossment. Is there any discussion to the motion? Seeing none, all those in favor signify by saying aye. Aye. Those opposed, the motion prevails. Next, we will move to the A10 amendment. Mr. Johnson, can you please explain the A10? And I have to commend Mr. Johnson on explaining the A8. Wow, well done.
Thank you, Mr. Chair. This one's going to be shorter. Currently, a person who is terminated from the ignition interlock program and can no longer participate, they will get that ignition interlock device removed, and they are not required to continue paying the ignition interlock company once that device has been removed from their car. That's in current law. The change in the amendment just clarifies that that also applies when a person voluntarily withdraws. So if a person voluntarily leaves the program and has the device removed, they don't have to continue paying a monthly fee for possessing that ignition interlock device. So it keeps those companies from creating a contract like a cell phone contract that even if you leave, you have to keep making regular payments.
Thank you, Mr. Johnson. So, Senator Latz, would you like to offer the A10 amendment to the Senate language, first unofficial engrossment?
Mr. Chairman, because Mr. Johnson used a great analogy to cell phone contracts, I will move adoption of the A10 amendment. Give us something to do next year.
Great. Senator Latz moves the A10 amendment to the Senate language, House File 2130, first unofficial engrossment. Any discussion to the motion? Yes. Chairman Moore.
Thank you, Mr. Chair. I just, for clarity, I'm a little confused why this is the Senate language and we're adopting the House language. So if we could just get an explanation as to why we're doing that would be helpful. Thank you.
Mr. Johnson, would take that?
Mr. Chair, Representative Mueller, so it's a side-by-side in a conference committee. So any and all of these provisions are fair game. Currently, they all match up except for the provisions that I explained at the beginning. By adopting the House language, you adopt all of the identical language and you adopt the appropriation. But that does not prevent you from adopting certain Senate provisions as well. And so this would be a motion to also adopt that Senate provision as amended. When we prepare the conference committee report, when the reviser does that, it will all be included.
And if I could add, the next step we'll do in this is to adopt that Senate language into the.
Always a step.
Great.
We're always playing catch-up with Chair Moeller.
Okay, any other discussion? All those in favor, please say aye. Aye. Any opposed? Okay, the motion prevails and the amendment is adopted. So Senator Latz, would you now like to move adoption of that Senate language?
Mr. Chairman, I move adoption of the Senate language.
So Senator Latz moved to adopt Section 17 of Senate language on R15 to R16. This is lines 18.16 to 19.6 as amended by the A10 amendment. Is there any discussion to the motion? Chair Mueller? No? Seeing none, all those in favor, please say aye. Aye. Any opposed? The motion prevails and the language is adopted. All right. There are no other amendments at this point, so therefore I will also move to adopt the entirety of the House language, House File 2130, fourth engrossment as amended. This is in addition to the inclusion of Senate Section 17. Any discussion to the motion? Senator Latz, would you like to make this motion? Can I? So Senator Latz, would you mind making the motion?
Mr. Chairman, I move to adopt the entirety of the House language, House File 2130, fourth engrossment, as amended, in addition to the inclusion of Senate Section 17.
Senator Latz made that excellent motion. Is there any discussion to the motion? Chair Moeller.
Thank you, Mr. Chair. I just wanted to thank you for your hard work on this bill, along with Chair Latz for your work on this, that resulted from work after a horrible tragedy in your community. So really appreciate that. And just also want to raise for the record is something that you and I discussed is potentially something to work on that I know Chair Cagle has been talking about for years, and that is for people who have driving incidents as a result of controlled substance offenses versus alcohol. Having to be on the interlock doesn't make a whole lot of sense for them, and it's very complicated to uncouple that from the interlock for alcohol-related offenses. It's something that I would like to keep working on and am committed to work on, and I hope we can get bipartisan and support from the other body as well to continue working on that issue. Thank you.
Thank you, Chair Moeller. Appreciate that. Representative Woody.
Thank you. I did want to echo, thank you both for your work on this. I know you did some work ahead of time to make everything line up with amendments and that. This will keep our roads safe and allow people that second chance, but it did come out of a tragedy, and I like that we're tightening up our DWI rules and that. So thank you both, and thank everyone on the committee.
Yeah, thank you. Senator Latz.
Mr. Chairman, I want to thank you for being such a great colleague and working through all this and really diving into an area of the law you didn't know anything about before this started. So now you are one of the few experts in DWI and driver's license law in the state legislature. But it's been a pleasure to work with you on this. I think this is a really important step forward for safety on Minnesota's roads. The ignition interlock is well recognized across the country as a safety device to help prevent tragedies like this. Part of the challenge has been getting people to do the program. And this bill does a couple of things to accomplish that. It reduces the financial barriers to getting into the program, certainly at the very front of the system. It also creates some incentives in terms of negative consequences if they choose not to enter the program. We'd rather have them driving with the interlock and insured and with a valid license than on the road without interlock, without insurance, without a valid license. We're all safer if that's the case. And so I think this moves all of us in the right direction, and I'm proud to be a part of it.
Thank you, Mr. Chair. Any other comments before we, so we still have to approve the motion. So all those in favor signify by saying aye.
Aye.
Aye. Any opposed? The motion prevails. So I also want to direct nonpartisan staff to prepare a conference committee report, and also direct that nonpartisan staff are empowered to make technical and conforming changes of the language approved by this conference committee in order to reflect the intent of this conference committee. Conference committee members, please keep an eye on your email to sign the report when it becomes available. And I want to make just a few final comments. I thank everyone for their participation on the committee. I especially want to thank the members of the Park Tavern community and the Methodist community for their participation, sharing their stories, and really being part of this, to shepherd this through along the way. It was an absolute tragedy that can never be, that hole can never be filled. But I do think that we're taking what we can and doing some good out of it. I also want to, as Senator Latz pointed out, I got into this and knew nothing about this area. But when I saw that this individual had 5 priors and started digging in with the help of Senator Latz, of Representative Witte, Chair Moeller, and especially with the help of Ben Johnson and Zach Meinertz here, we started on this journey back in September last year, and you helped me learn and helped really lay out the path for, I think, what's really impactful legislation. So I think this came together really well, and I want to thank the two of you especially very much. So with that, thank you, members. Seeing no further business before this conference committee, we are adjourned.